Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
Well, today we got Pat Salvi Jr. from the windy city of Chicago. Is it pretty cold there today, Pat?
You know, it's a beautiful day. It was like typical Chicago. It was 80 degrees 2 days ago. Then it,
Really?
then it was 20 degrees yesterday. And now it's coming back up. I think it's in the 40s or 50s. So it's really nice out today.
That is great. Chicago is one of my favorite cities in the whole world. I actually love Chicago and I actually got my beginning in Chicago because I went to the AAJ when it was there, I think in like 2012, right around there. It was my first AAJ and I connected with Nick Rowley there because we had not spoke for a while or not seen each other for a while. And then he invited me to come listen to him speak at Cala in Las Vegas a couple months after that. And right after that, I moved to California. And so Chicago will always be
Can I
right
can I
here.
tell you something about that conference? So Vice President Joe Biden spoke at that conference. He gave a great speech. Part of his speech was, don't tell me your values, show me your budget, and I'll tell you your values. And I've said that in closing arguments. I thought that was a really interesting way to put it. You know, what you put value in says a lot about you. And so I try to impress upon juries that same thing, that if you put value in love and being pain free and relationships and happiness, and all the things that have very typically been taken from our clients due to the wrongful conduct of others, then put a big number on it if that's how you feel, if that's what your values are, if that's what the community's values are. So I'll always remember that speech. It was a good one.
You know, to say it more succinctly, it's like put your money where your mouth is. That's often it. My brother, who has since moved on to a different world, but he used to say, "Don't let your mouth write checks that your back can't cash." I don't know why that came up to me, but it just did. Anyway, I thought that was a clever thing to say too. People talk a lot. But Pat Salvi Jr., what are you, 40 years old, 41 years old?
I'm 42.
42, well, you're quite a bit older than I anticipated, but still, you've gotten to a very high point in your career at a very young age. So that I think is what most people want because, you know, we all want to get to greatness as fast as we can. I know I do. And that's what I'm working on diligently every day. But let's move back in time a little bit. How did I know your dad's a very well known lawyer, but when did you decide, you know what, this law thing, this is going to be for me too?
Yeah, so I grew up around it, and I had a lot of Saturdays growing up where I would tag along to the office and, playing with my toys or whatever as my dad would, work on a Saturday, and that was always fun. I'm very close with my dad, always have been. And I do have a distinct memory because it wasn't as though, and I give him a lot of credit, he never put pressure on me. It was never pushy or anything like that, no expectation. I suppose he was more subtle about it because he would tell me, oh, Patrick, you'd be good at it. So that was maybe his subtle way to push me towards being a lawyer. But I do remember very distinctly, I was an okay student in high school. I, studied kind of enough to get by, but never really applied myself in a way that was, competitive and wanting to get the best grades possible. But I did well enough. I could kind of skate by on some, natural ability. And then when I was in college, I went to the University of Colorado, which was just fantastic. And I started my freshman year, and I'm studying, and I called my dad once and I said, "Hey, Dad, I know why I wanted to get good grades in high school so you can get into college and all that. But what's the point of grades in college?" And he goes, "Well, do you want to get into a good law school?" And something kind of clicked there because I guess even at 18 years old, I hadn't thought ahead all that much. I hadn't really mapped out a plan. Becoming a lawyer was kind of always a possibility. But then from that point forward, I really did. Something about him saying that really did click for me. And I did want to get the top grades that I could get, which I applied myself and I did pretty well. And I took some courses that where you'd read case law and have debates and take a position in an argument, and that was really exciting. And I felt like I was good at it, and it got me going in terms of wanting to sink time into it and get really really good at it. And then I ended up applying and getting into Notre Dame Law School, which was really super exciting for me. My parents actually met at Notre Dame. My dad went there. My grandpa went to Notre Dame undergraduate, and then a number of my brothers followed in my footsteps after I did. So that was really fun, and that's what kind of kick-started at least becoming a lawyer, and then the evolution of ultimately going into personal injury law and being a trial lawyer. That kind of came later as the years unfolded thereafter.
Well, in law school at Notre Dame, did you participate in like moot court, trial advocacy, or anything like that to help you get ready for, the courtroom?
I did. I actually had the same professor as my dad. He's been around forever, Jim Seckinger. So I tried
Wow.
out for trial ad. Yeah. I tried out for trial ad, made the team. That was exciting. Had some really good friends on the trial ad team, and we didn't win the national championships in all of our competitions, but we did pretty well. And that was definitely an eye-opening experience into being a trial lawyer. And so that was part of the evolution. I wasn't sure, I've always been a huge sports fan, a Chicago sports fan, a Notre Dame sports fan. I've always been a huge sports fan. So when I was thinking about what areas of the law to go into, that was kind of always in the back of my mind. Do I want to be a sports agent or work for a team or a league or something like that? And that never really materialized. And doing the mock trial, kind of for all the reasons you might expect, you kind of, you get into it and it's exciting and you're on your feet and you're in front of people and you're competing. That drew me in.
Yeah, and I know you got to get practice time on your feet. I never did any of that stuff. I just thought, oh, this is a waste of time. But of course, I didn't know shit back then, so I wish I'd got a little more reps, but didn't happen for me. So you get done with law school, and afterwards, tell us about your career. Where do you get started at when you first started to get out of law school?
Yeah, so I've been practicing almost 18 years. I went straight with my dad. I think at the time it was, nine or 10 lawyers right around there. We had a small presence in Chicago. Our primary office was in Waukegan, which is Lake County, just north of Cook County, where Chicago is, kind of the northernmost county before you get to Wisconsin. And so, it was a different looking firm back then. But I kind of, at the time, I kind of took the easy way and joined with my dad. And I took those first few years to kind of figure things out, some ups and downs that I'm sure we're going to talk a little bit about, and just trying to figure out if this was for me. And it was really over those first years of practice, where you take some lumps, you have some successes, and you get to a point where you ask yourself, do I really want to dig into this? Is this something where I want to devote myself to becoming great at this, or is it not for me? And I had plenty of moments early on which could have gone either way, but I think that at the end of the day, just the confluence of the people we were representing, the type of practice we had. I enjoyed working with my dad. Like I said earlier, we're very close. We get along great. We've tried a number of cases together. He's been great to me ever since I began, in terms of giving me opportunities and letting me fail, and in certain ways being a great mentor, in other ways just kind of throwing me out there and trial by fire. So a little bit of all of that. But I've been with this firm ever since, and now we're 22 lawyers. We just expanded onto a second floor at our building in Chicago. The growth has been very exciting.
Sounds pretty exciting. And it's interesting because I know a lot of lawyers who are famous and great who have sons or children who become lawyers. And, the truth is, the vast majority of them don't become shit. They just, you know what I mean? It's like they just can't handle the shadow. It's weird. And, and it's like anybody that, is in this world and, act in this world knows exactly who these people are. But Because I am more politically correct, will not name names, but it's true. It just happens that way. If you've been hand, sometimes it seems like you just got too much of too big a start. You just don't push yourself. You just assume that because your last name or who your dad is, something great's going to happen for you. And it's those, I think that's what causes, so many of these children of the great ones to become somewhat just not very good, even pathetic. And so it was a challenge for you in obviously accepting, being grateful that, people knew who you were because you're a dad and you have the same name, and, opens up a little bit of door, but also that shadow and, making your own name and, making your own way in the world. So what was that like for you?
There's absolutely no doubt that I've been afforded great opportunity. Our firm has had good cases. I've had great mentors, my dad included. Also, the other named partners, one of whom passed away at a young age in his early 50s from a glioblastoma, Mike Shostak, was a great mentor. And David Pritchard, who retired 11 years ago, he was a great mentor. I have had tremendous opportunity. I think it starts with you can't start on third base and think you hit a triple. You got to have some humility, even when you're able to come into a good firm with a good reputation, with top flight lawyers as the partners, and kind of the path that's already been created for you. If you just want to walk that path and act like you earned it, then I think that's when you're in for trouble. It's you're where you're going to have complacency. And so my approach from the beginning, I think in a good way, I always had this insecurity, this defensiveness. I tried to keep it to myself. I wouldn't want to be a jerk about it. I wouldn't want if people talked about my dad or talked about being his son. I mean, to this day, I get it a lot from lawyers. Say hi to your dad for me, or how's your, people ask about my dad, which is fine. But from my perspective, as I was accumulating years of practice, what I would say, I would use it as motivation. And in terms of people outside the office, there's only so much you can control in terms of outside the office, how people are going to think about you, what your reputation is, might be based on reality. It might be based on something that's not real. Only so much you can control. What you can really control, and what has been much more important to me than my reputation outside the four walls of our office, is my reputation within the office. And so whether it's the receptionists, the assistants, the paralegals, the other lawyers that are either, my age, older, younger, I always wanted them to truly respect what I was doing. And you don't get that respect just because of what your last name is. You got to earn that respect. And so I think that if you ask folks around the office, they would say, Pat's the hardest working lawyer in the office, or at least, nobody works harder than Pat. We got a lot of hard workers. I'm not necessarily comparing, but that my work ethic is not really questioned by them. That they know that I'm going to be working as hard as anybody, and that they can trust me, and that they know that when I am strategizing about a case, or when I ask them to do something, that the bigger plan is a good one, and we've demonstrated that. We've proven it in terms of the way we run our trial teams, that the people in this office, when they are asked to do something by me or by someone else that's in leadership, that they are confident in that. And the only way to earn that is through your work ethic and showing that you have good judgment, and that you're going to work hard to make good decisions, which requires significant preparation. So I focused on that at the beginning, and I think that has been a major aspect, along with the other great people that we have at this firm, because we are extremely deliberate as to who we invite into our tent at all levels, lawyers, staff, it doesn't matter. You have to have high integrity. And so,
What podcast you
for
decide
the
to appear on?
That's
There
right,
you go.
only
So
the
don't
best.
forget about
We're not,
TLU, buddy.
yeah, yeah, we're not gonna do just any old
No,
podcast. It's got
no.
to be the highest of quality, which is why I'm here.
There we go.
Uh, but I am very gracious and thankful to you, Dan, for having me on, because I've learned a lot from this podcast and listening to some of your guests. It's really remarkable, some of the information that's shared. And so that's how we've done it. That's how I think I've done it. It's kind of on from the inside out. And our team approach here at the firm is something that I believe very, very firmly in, and something that I think has benefited us. So in terms of stepping outside the shadow of my dad, it really has started in-house. And then I think as you accumulate results, as people see you in the community, as you're getting verdicts, I had an opportunity to be president of the Illinois Trial Lawyers Association and on the executive committee in the lead up to that. So that's highly visible, and people can see your work ethic and your ideas through that experience. So I think that just comes naturally if you're doing the right thing day by day, and then having your team behind you here at the office. I mean, that's the most important thing. That's what serves our clients the best, is what we do here.
Yeah, let me ask you about that presidency of the Illinois Trial Lawyers, because the reality is, for most organizations, usually the real trial lawyers aren't there in the politics of it all, becoming the president, because they're too busy trying cases. And those organizations, a lot of politics, a lot of running around the state capitals and stuff. So first of all, what motivated you to want to become, on the ladder and then the president of the Illinois Trial Lawyers?
Yeah. Well, there's really no doubt that if you look in the Midwest, we're kind of a blue island in terms of civil justice and the rights of our clients being preserved. There's a lot
Indiana,
of caps
Ohio,
on.
you're in
Yeah,
the middle of a real
look
shit show
around.
out there.
Look around. There's probably, you go a little north to Wisconsin, Iowa, Missouri, Indiana, Michigan. There are some issues that those states deal with in terms of civil justice that we don't. And it's not by accident. I mean, when I say I stand on the shoulders of giants, I mean it. Going all the way back to guys like Leonard Ring and Phil Corboy Sr. More recently, my dad, who was a president in the early 90s, along with Joe Power and Bob Clifford and some of the other titans in Chicago, all of whom pretty much, by and large, have at one point or another been the president of the Illinois Trial Lawyers Association. And a lot of them did it at a young age, and then for decades thereafter were able to give their know-how and their intellectual capital back to the organization, and remain still very involved today, into their 70s, which isn't going to, that's not going to go on forever. And so there needs to be a younger set of leaders to come in and contribute as well. And so through, time, talent, and treasure, you have to give back, because the civil justice system and the rights that are afforded to our clients, I mean, they can be taken away in a nanosecond if you're not paying attention. And so we're very diligent about it. So whereas perhaps in other venues, the top trial lawyers are not getting significantly involved, I'd say that's not the case in Illinois. I would say that the top trial lawyers are leading the charge, doing the fundraising, doing the looking at bills and proposing legislation and all the different things on the margins that can affect, our clients' rights, Supreme Court rules, evidence rules, whatever the case may be, the jury instructions. And so it's very important that, we're involved. So I got involved at a young age, and, the time was right. And I was able to be president a couple years ago. And during that year, the legislation that, we got behind, I think fixed some inequities and really did a lot of good for clients' rights in Illinois, and of course played defense and protected from any bad legislation that would slash right.
Well, what legislation did you get passed?
Yeah, glad you asked, Dan.
Hey, I
So
gotta listen.
two big ones that I really like. One is pretty basic for anybody listening to this, particularly plaintiffs lawyers, who I imagine are most of your audience. In Illinois, we did not have punitive damages for death cases. So punitive damages available for injury cases. There is a bar on punitive damages for medical malpractice, which is that's a highly charged political issue. We weren't able to attack that. But in terms of punitive damages in wrongful death cases, because it wasn't specifically written into the statute for decades, this arcane belief that it's statutory creation and therefore needs to be blessed by the legislature, it was never done. And so we made the push and ultimately passed, and the governor signed the bill to allow for punitive damages in wrongful death cases, which just didn't make any sense. So that was one of them. So now you can get punitive damages in death cases. The second one was for, so these rideshare companies are very active politically in the state houses and,
Oh yeah,
and,
Uber
and
tried to
federally.
pass some bullshit law in Vegas to limit attorney fees to 20%. Scared the living crap out of everybody there practicing, but the Supreme Court knocked it down, I think, as unconstitutional. I mean, which makes a lot of sense. But yeah, that's why we're a lit people around here. They're not the ones. They don't seem to be as active trying to disrupt stuff as Uber. But go ahead.
Yeah, well, they were able to obtain common carrier exemption and common carrier law, the jury instruction that allows you to tell the jury that common carriers owe the highest duty of care. Common carriers are they're also responsible for any intentional torts perpetrated by their agents. So if you're able to prove agency, which is never a given in those cases, but if you're able to do it, then they are responsible for things such as sexual assault because they're common carriers. Though you do have to prove agency, which is a challenge, but can be done. For example, in Missouri, it's a statutory bar. You cannot prove agency. You would have to have some direct action against the rideshare company to collect for something that their driver did above and beyond the policies that they write for them. So in Illinois, we got rid of the common carrier exception. It didn't make sense anymore. They had entered the market. The thought process behind the initial legislation was that they need to be able to compete with taxi cabs, et cetera. Well, now they're dominating taxi cabs. And so we made the argument that them having a common carrier exception when trains, planes, taxi cabs, water taxis on the Chicago River, and anybody else is a common carrier, so too should rideshare companies. And so we were able to get rid of that exemption, which I think was good. Good for safety.
Good for safety. Speaking of
That's
things that are
right.
good for safety, let's talk about when you get your first seven-figure verdict.
Yeah.
That's always, I think those are milestones. First six-figure verdict, seven-figure verdict, eight-figure verdict, nine-figure verdict. So talk about your first seven-figure verdict. Give us a quick, how old were you? Quick summary of it. A lot of people are still trying to get their first seven-figure verdict, Salvi, present company included.
I gotta break this down to two different cases because it really is two different times in my career. So my first seven-figure verdict as first chair certainly, at least in part, came from a philosophy that I've very much tried to push at our firm, and I think it's very important.
When you see a softball swing.
Try your good cases and settle your bad cases. In fact, maybe try not to even take bad cases, right?
Right.
How about that? But try your good cases and settle those cases that perhaps don't have the ingredients relative to a big result at trial. So this was a good case. This was a head-on collision. It was entirely the other person's fault. In fact, I think in discovery we learned that he was doing some real estate scouting where he was looking at properties and dictating into a dictaphone while he was driving, and then he caused a rear end collision, went across the center line, head-on collision with my client who had a really bad tib fib fracture along with a patella fracture, needed rods and screws and the whole nine yards. And so she was young. My client was young, but it was a very strong liability case. They ultimately admitted liability. They offered 250. That wasn't good enough. There was a $2.1 million policy. We asked for 3 million and got 1.3 million. And I was on top of the world. It was a relatively short trial, just I think Monday to Friday, some experts, some treaters, some lay witnesses, and that was it. And I was on top of the world. I was absolutely on top of the world. I thought this was great. I will say this though, and there was a lot of wisdom behind this. Mike Shostak, who, as I mentioned earlier, one of my mentors, one of the partners before he passed away about 13 years ago, he was like, "Hey, Pat, great job, but they're not always going to be that easy." So he did give me that warning. Well, 2 months later, I went and tried a case where there was a good offer on the case. It was like a mid six-figure offer, which at the time that was a big offer. But I felt like I'm the man. I can do this. I've only been practicing. So I was practicing about 2 years, and I'm like I can I know what I'm doing. And so we rejected that offer, and we went to trial on a case that had a weather defense and the little old lady defense. I mean, if anybody's tried a case where the defendant is a little old lady, and Pearl Hoy, I'll never forget her. She was nice, not the easiest cross-examination. I think she was 75 years old, very, very nice lady, but she lost control in the snow, crossed the center line, and my client, who was a union electrician, she broke her wrist pretty bad, and I had big wage loss claim, and figured we could hit big on this one, get a few $1 million, and show that defense lawyer why a mid six-figure offer was no good. Well, that jury came back before I sat down for lunch after I got back to the office after closing argument. I think it was 20 minutes, so I may have set the record for quickest verdict. If not the record, it's up there. And that was devastating. And that was a shell shock to the point where it had an impact on me in terms of my ability to be risk tolerant. And for the first 7 years or so of my career, that was around year 2, there's no doubt I did not try as many cases I should have tried. And every plaintiff's lawyer listening knows what I'm talking about, where you get an offer and it's okay, and you could talk your client into it, and you can rationalize as to why it's the right thing to do and the right thing to recommend. But really, you should try that case. It's a good case, you're going to win, and you're likely to do better. Go try that case. And there were plenty of instances in my first 7 years where I look back and quite frankly, I didn't do that. I was afraid. And that case had a little something to do with it. I had other experiences where, a tough med mal kind of trickled down in the office, and I'd have to go fall on a sword and get my teeth kicked in. And I had those experiences too, which you learn from. You definitely learn from. But it was around year 7, not too far off from that 2000, a little after that 2012 AAJ conference, because AAJ had a big part in this as well, where I started going to seminars outside of Illinois and talking to lawyers from outside of Illinois. And nothing's wrong with Illinois. I mean, there are great lawyers who have taught other Illinois lawyers a lot over the years. I mean, the folks that I've mentioned already, former presidents of ITLA, they are unbelievable, and they share their knowledge. But it's good to get outside your state bubble and learn some new things. And so I started studying more and researching more and thinking about psychology and memory and persuasion and how human beings make decisions, and studying that with a lot more depth. And I hadn't been doing that yet. And with that study, I felt like I built kind of at least a foundation of how people go through the thought process of how they're going to feel about a case, how they're going to deliberate, what they're going to remember during trial, what you want to emphasize, how you want to emphasize it. And focusing on those things, you're no longer trying a case as if it was 12 of you. I think lawyers make that mistake. They try the case thinking about how they would be persuaded, and you have to take a step back and think about how people of all different walks of life are going to be persuaded, and learn the science of decision making. And that's kind of when I did it. And so I was about 7 years into my practice. So this is 11 years ago, 2014. And I tried a really tough case downstate. It had gotten some local press. It was really at the tip of the state, like right across the border from Kentucky. It had gotten some local press where it looked like the 13-year-old who was on the bicycle, like it was all his fault. He ran a stop sign. He was going downhill, went through a stop sign and got hit by an ambulance, and that it was, the boy's fault. And that's how some of the press clippings read. Police officers didn't give any tickets, no tickets to the ambulance. And it seemed like it was a very tragic situation, but his fault. We investigated it, and it looked like a couple of things were true that didn't get much reporting. Number one, the ambulance was driving too fast, and it looked like we were going to be able to prove that through some crash reconstruction, through some of the witness statements that were given. Also, that the ambulance was over the center line and actually struck the bicycle rider while over the center line. And so that was the theory. It was a no offer case, lots of experts, crash reconstruction. They hired a bike guy out of Colorado who's a bike expert, so they threw the kitchen sink at us. It was a 2-week trial in a venue. 400 people live in the town, 4,000 people live in the county, very small county at the tip of Illinois. Biggest verdict. I was asking the clerk, I said, what was the last time you had a plaintiff's verdict? He goes, oh, we had one last year. I go, how much was it? He was like, I think it was $500. I was like, what happened? He's like, it was a dog bite. I go, what were the medical bills? He goes, $500. So they weren't much into non-economic damages, and that's all we had. And so, this is a place where houses cost $25,000. It's a modest means in this particular county. I think the biggest verdict in the history of the county was either $50,000 or $100,000 in that range. So we got $2 million gross. There was some contrib, so it knocked it down to 1.2. Tough case, tough liability case, but that was one that really propelled me and gave me more confidence, even when there was a decent liability defense coming at me, that you could still win. because I think until that point I was very skeptical about jury decision making because I didn't really understand it. I didn't understand how to tap into it. And it was after that case that I felt like I developed more confidence, and then you want to get back in the courtroom more and more and more, and it just kind of feeds on itself.
Okay, that was a seven-figure verdict that you were proud of. You got back on the horse
Yeah,
after getting your ass kicked and getting
that's
your ass
right.
kicked again and again. So once you get back on the horse, you got your confidence back. So let's talk about your first eight-figure verdict. What was that case about? When did that happen for you?
So my first eight-figure verdict was during a time where I was able to, I mean, this case came in the door. It was a guy about my age. And this happened. The verdict I just told you about, the case I'm about to tell you about now, was going on at the time and ended up being tried a year later. But it was a case, it was one of those cases where I was just totally wrapped up in discovery. I mean, tons of depositions, every little detail. It became like a running joke in the office. It's my client is Tom Newhagen. There's an appellate decision. I can talk about in a moment, but Tom Newhagen. He had his foot run over by a forklift at a trade show here in Chicago, and the main defense was contributory negligence. It was his fault, but because of the aggressive nature of our investigation and some of the facts, we had some good facts, including that this forklift operator, even though he had been doing it for 40 years, he didn't have an up-to-date OSHA certification. That was something that this company that was responsible, they had some problems with OSHA in the past in terms of being cited for violations, not training their forklift operators adequately. And so we pursued punitive damages for that. And ultimately, he kept his foot. There was a question at the early stages that he might have an amputation, but after some surgeries, they were able to salvage his foot, but it was a bad foot injury. He was a hardworking guy, so he maximized his recovery best he could. But it was a bad foot injury. We got 12 million in compensatory, 3 million in punitive. It was a knockdown, drag out fight, 3 week trial, fighting us on some very serious legal issues relative to whether or not we could get punitive damages when it was a theory of reckless hiring, and there were some proximate cause issues that went up on appeal. And ultimately, what happened was the trial judge threw out our punitive damages because she said we didn't prove proximate cause. In essence, the forklift operator got on the stand, and because questions from his own lawyer, he said, "Oh yeah, the training that I didn't receive, I knew all that anyways. I knew to do X, Y, and Z, so I wouldn't have learned anything." And the judge just said, "Well, if you wouldn't have learned anything, there's no causation." And that didn't seem to make a whole lot of sense. So we went up on appeal, and ultimately, I mean, there was cross appeals. They were trying to get the whole verdict thrown out. Verdict was excessive, etc. And ultimately, we won. We won on appeal. The Supreme Court denied their petition for leave to appeal, and it was a $15.2 million verdict. We ended up collecting 19.5 with the interest. That was a long, drawn out battle that was very satisfying.
I imagine it was. $20 million. That's very satisfying.
Yeah.
I can only imagine.
Yes.
And so you have to practice in the deposition. You practice in motion hearings. You practice at the grocery store. That's why you have a family. You practice on them. You have to keep the skill up or it erodes. It's simple as that.
Somebody give us an overview of this case.
Or I call wowing it. And what I mean by wisdom of the wise is, why are we still right in spite of this fact?
These are just some of the clips when I was prosecutor 10 years ago, remember that.
About 11 o'clock at night, and he leaves this message. "I got a brilliant idea." Every conversation he starts, "I have a brilliant idea."
But welcome, everybody. We've got a good crowd here today.
All right, but then you even had a 9-figure verdict, and I know this is something that not just the verdict itself, but the process to get there. That in getting ready for this, I said, "What are you most proud of?" And it was this verdict. So, as
Yes.
professionally speaking, in your 18-year storied career, this verdict is the accomplishment you're most proud of professionally. Is that right?
Yes.
Sterigenics.
Well, you're talking about the ethylene oxide verdicts against Sterigenics. So that was a $363 million verdict. And I'll give you a little bit of the backstory. But before I do, one thing I'll say about my dad is I think of him as just the king of damages. I think he is as good as it gets when it comes to damages. I told you about an admitted liability case that was my first seven-figure verdict, and I told you about a philosophy, try your good cases. A lawyer, one of my buddies, Brad Cosgrove, who's just an unbelievable trial lawyer here in Chicago, he'll make fun of me because I've, every now and then I'm trying an admitted liability case, and he makes fun of me for it. Oh, you're trying another one of those admitted liability cases? And I joke back with him. I say, well, don't you work them up well enough to where they admit liability? Maybe you should do discovery a little better. I say that because the first nine-figure verdict that I was on, I was not first chair. I picked part of the jury. I did a number of witnesses. I was not first chair. My dad was. It was an admitted liability case. And that was because of how well we worked up the case. Not me personally, but others at the office. And it was ultimately for a spinal cord injury. It was $148 million, no punitive damages, all compensatory. It was against the city of Chicago, so punitive damages are not available in Illinois against municipal entities. And so that $148 million verdict was one where one of my great contributions was they were the team, before I got invited on, about a month or two before trial, was saying, well, we're going to ask for $100 million. And I said, well, why not ask for $200 million? And so we tested that a little bit, and ultimately the request was $175 million. Verdict was 148. That was an incredible learning experience and something that I learned about damages. And I don't think you can talk about the Sterigenics verdict without talking about that at least a little bit. Now, Sterigenics by no means was an admitted liability case. Anybody that knows anything about these ethylene oxide cases is that the causation is challenging. The epidemiology is not great for plaintiffs. I firmly believe that ethylene oxide causes a whole heck of a lot of cancer, and it actually affects even the background numbers, but that's more of a theory than based in science. But that being said, the Sterigenics case was just about a community that had ethylene oxide, a known carcinogen, put out into the atmosphere by a local company, a company that had moved in the mid 80s and had been there all the way through 2019 when the Illinois government ultimately shut them down because of the danger they were posing to the community. And so during those 34 years, they were in differing levels putting out this ethylene oxide into the community. Into the air. Now, air cases are tough. You do air modeling, you do the best you can to try to ascertain how much your client was exposed to, how much they breathed in. You do your best. It's not an exact science. And so the Sterigenics case was one where in the whole litigation, there were almost 900 plaintiffs. Our firm had about 250 of them. There were 21 other law firms involved. There were 7 firms on the executive committee, and I was one of 3 lawyers who were considered the lead counsel, Sean Collins and Tony Romanucci being the other 2. And then I had also the privilege and honor of representing Sue Kamuta, who we had happened to file the first case. The first case got set for trial first, and so we were the first trial. So I was the lead trial lawyer and the co-lead for the litigation. We tried to really, and when I say we, I mean our firm, we tried to really bring just great ideas and energy to the litigation every day. This really became my focus. There was a point in time in 2022 in the months before trial where literally I put every one of my cases aside and had to step away from every case that I was working on so that I could focus on this because it was that kind of a time commitment. Just to give you a little bit of that, 19 expert depositions in May. We did 19 defense experts in 22 days as we crunched prior to trial, which was a little uncomfortable, but we had to do it. And so totally focused on this case. I had 5 other lawyers that had witnesses or some responsibility during trial. I mean this in a good way. What I'm about to say, all 5 of them at one point or another came to me disappointed with how much they had to do, how many witnesses they were handling. They wanted more witnesses. I don't blame them for that. These are all great trial lawyers who just wanted more. But at the end of the day, as the lead, I was the GM. I had to put everybody in a position that I felt was best. And really what they were advocating for were things that I was putting on myself, frankly, opening, closing, jury selection, certain witnesses. And so part of my challenge, just to try to be a good leader, was to get everybody to come together to do their part, whatever it was, with excellence. And so the case was, if you count all the motions in limine that we had probably 2 full weeks of motions in limine in July, tried the case for another 2 months into late September, mid to late September. That was also a knockdown, drag out fight. We had, full courtroom almost every day, press almost every day. There were a lot of eyes on this case because there was a lot of local news when this company was first identified by the federal EPA as potentially causing an increased risk of cancer in the community. And so, after 6 weeks and no offers, no nothing. In fact, not only were there no offers, the lawyers really had a little bit of an arrogance about them in terms of what they believed was their likelihood of success. I mean, you could just kind of tell that they felt very confident. And so when it came back, I asked for 21 million in compensatory, 325 million in punitive. When it came back, 38 million for compensatory, so almost twice as much as what I asked for, and 325 million in punitive, the exact same amount that I asked for, and then 12 for 12 on all of the counts: public nuisance, battery, negligence, willful and wanton, 3 different companies, 4 counts against each, 12 for 12, clean sweep. That was as satisfying as it gets. And one of the great parts about it was the team. I already mentioned there were 5 other lawyers that had witnesses, not just them, but the whole staff that was working with me till past midnight, many nights as we were doing critical corporate representative adverse examinations and things like that. It was really just an amazing crescendo on behalf of a very deserving client who put herself out there, willing to be the first case. Our client, Sue, who had breast cancer and was in remission, thankfully, but of course went through a lot, was also just an incredible plaintiff with a wonderful family. And in fact, during the course of the litigation and in just the less than a year before the trial, her son, so she had breast cancer, which was one of the cancers that's linked to ethylene oxide. Her son was diagnosed with non-Hodgkin's lymphoma, which is a blood cancer also with a connection to ethylene oxide. It's really breast cancer and blood cancers that have epidemiological support primarily. And so his case, and so we filed a case for him. It was joined with his mom's case, but then right before trial, it was severed, which was we thought a very big blow. It ended up being a kind of a blessing in disguise, but we thought it was a huge blow in terms of proving causation. The biggest challenge was proving causation, and we figured having 2 people in the same household, how better to prove causation. And so when it was severed, that was very concerning. But then to get the win despite that bit of adversity for that family, because not only had Sue had breast cancer some years before, in remission, had not dealt with any recurrences, they had, her son, Brian, dealing with it. He was in his he's in his late 40s. He's got, wife, 3 kids, beautiful family, so it was very emotionally charged because they were dealing with the effects of what this company had done right then in the moment, even though we couldn't talk about it in evidence. So for all those reasons, that is my favorite lawyer moment, was when that verdict was read.
And so we're going to be able to talk about that favorite lawyer moment in depth on May 27th, because we're going to do a case analysis on that verdict, which will be very insightful. And if you can't make it to that live event, it will be recorded and will be on TLU On Demand, just letting everybody know. Because, Pat, you don't know this, but TLU On Demand is now not just an app for your phone, but if you go to use the desktop version, it has a new AI feature appropriately named Dan GPT. So, therefore, if you want to know anything within the vast knowledge of the Trial Lawyers University database, you can just ask the question and it'll answer it for you. Or if you're searching for a particular video or a particular, punitive damages, like my friend Kimball Jones, he's just gotten 3 9-figure verdicts in the last 8 months on insurance bad faith cases. And he was talking in Vegas in 2024, which you missed, but you're probably in trial, but that's not okay. We're going to talk about Huntington Beach, so you're not going to miss that. But he's like, hey, when I got the punitive damage part, I know what to do because I really planned on it. On his first one, he's like, I went on TLU On Demand, searched punitive damages, got some ideas, put something together, and went and got my $120 million, $5 million verdict the next day. So you see, TLU On Demand has been responsible for a lot of Fantastic. Well, contributions, let's put it that way. And if anybody's listening and doesn't have it, if you send me an email or a text, I will shoot you a 30-day trial access so you can see how great it is and how much you're going to learn from it. Anyways, that was just a little side note for the on-demand. You're also going to do another webinar on, I think we said, April 9th on the, how do you say that name? Husin? A med-mal case?
Yes, correct. Yeah, it's a birth injury case. That's correct.
All right.
Kind of a unique birth injury case. Yeah.
What's so unique about it?
Well, it's not a traditional strip case. It had to do with a particular maneuver that the physician did that we were very critical of, and it ended up causing trauma. So there was a bad brachial plexus injury along with a bad head injury. And, we faced a number of very creative defenses. We had, a tough, likable defendant, a defense lawyer that knows birth injury cases backwards and forwards. So that was a battle, but we were able to emerge victorious. That was a $76 million verdict, that we're very proud of.
I bet you are. And all these verdicts had led to your being invited to the inner circle, which, my friend Brian Panish and is very active in. Like he's not many organizations he likes, but he really likes that organization and really puts a lot of effort into it. So, what was that like for you when you got your, letter in the mail letting you know that you were being considered and, all the hoops you have to jump through?
That was pretty cool. So it was, I got an email that was inviting me to apply. The timing of it just caught me off guard. I of course, wasn't expecting it. It was very exciting. I had the good fortune of, some of the local Chicago trial lawyers that are part of that organization who I could talk to about it. So, for example, Tom Demetrio was really instrumental in kind of talking me through some things. And I go to fill out the application. It's kind of interesting. I mean, it's an organization where if you look at the roster, I mean, the who's who of trial lawyers, it can be very intimidating. And so I wanted my application to be like perfect. So I worked very hard at that application, and lo and behold, I show up for my interview, and you got titans of the trial bar there. You had Brian Panish, you had Joe Power, you had the president Judy Livingston, you had Dennis Donnelly from New Jersey. Tom Klein was asking me some questions as well. Others too. I mean, those aren't the only folks. But as you can imagine, a lot of the focus, it really, from the beginning of my career, going back to what we were discussing earlier, a lot of the focus was like, hey, do you try cases without your dad? And so I had to go back and make very clear with my trial list that, hey, here are the cases that I tried where he wasn't part of the trial team. And then ultimately, after I think I demonstrated that many of the verdicts that have my name on it don't have Pat Sr. as well, then I got the call from Judy that I had been invited into the inner circle, which was really fun, and went to Laguna last August for their annual event, and boy, was that a trip. I mean, that was, not only was it beautiful and fun, I had my wife there, my parents were there. You get to give a speech when you're inaugurated and brought into the organization and talk about a case and talk about your life. So that was really fun, because it's really, there's nothing better, more that I'd like to talk about than this stuff, than what we're doing right now. And then just a couple of weeks ago, I was in Scottsdale, and so you're just being around. I mean, it's very similar to Trial Lawyers University in the sense that just listening to and being around and talking to and hearing from the great trial lawyers, you can't help but learn. You're going to pick something up that's going to be able to benefit your clients. And so there's a lot of that going on at the Inner Circle, and I'll say that just the folks that are in that organization are just really top-notch people, very welcoming and kind, and I feel very fortunate to be a part of it.
That's true. I know a lot of them, like Lloyd Bell, Dale Gallipo, obviously Panish, Randy McGinn, and they're all coming to TLU Huntington Beach with you. About time. I was waiting for you to get to the inner circle before I actually invited you. I hope you don't take that personally. It's nothing. It's no slant on you. It's no shade on you. But we have to have standards at Trial Lawyers University. So
I needed some street cred. I get it.
That's it, buddy. Because that's it. You're a young guy. I got all these superstars here. So, but in all seriousness, TLU Huntington Beach is coming up June 4th through 7th. And, if you're coming, you want to get there on June 3rd, because it'll be fun activities on the afternoon of the 3rd. Ed Saramboli's hosting surf camp for some folks who want to learn how to surf. Our good buddy Kurt Zahner, he's going to take some folks out and, go-kart racing. Maybe you want to go do that with him. It's going to be pretty fun though. And so there's fun stuff to do on there. We're going to have 8 workshop tracks, 4 lecture tracks, and the workshops are a combination of small group training because I've been teaching this boot camp now for a few years. So there's like half-day sessions on cross-examination, jury selection, presentation skills / opening statement. But there's also some of these master classes. And so like Nick Rowley's doing a 1-day traumatic brain injury masterclass on Friday, June 6th. But my other buddy, Sagi Shaked, and Connell Doyer also teaching a TBI masterclass the day before. So different, people have gotten great results on TBI. It's just 2 different perspectives on how they put together, screen, build their TBI cases. Gallipo's doing a masterclass on civil rights, a 1-day class, because that guy, those are the hardest cases against the cops. And people are like, oh, well, cops are beating the shit out of everybody these days. So I'm like, that's true. But, when it comes to your own police and your own communities, most people, unless they've done something egregious, are often inclined to give the police a pass. And I know that you just got a great result recently on a police chase case. So against that city of Chicago, man, they really like to stuff the money into the law firm, don't they? I mean, keep it all.
Well, they got to clean some things up. No, we did. We had 2 police pursuit cases over the course of the last year. One was a brain injury, one was a death, as well as some other injuries, and 2 big results. And we're not the only firm. I mean, there's some other firms, whether it's wrongful conviction or what have you, that the city of Chicago's got some cleaning up to do. I hope they do that. Those can be very tough cases for all the reasons you said. I mean, a police pursuit case, for example, you're always losing sleep at night about, well, how much are they going to blame the bad guy, the eluding offender? Because they're the ones that, at least in the 2 cases I'm talking about, the one that we just tried, they're the ones that cranked it up to 90 miles an hour, directly caused the crash, went through the stop sign. The police are out there trying to patrol the streets and keep the bad guys off the streets, catch the bad guys. And so that's what keeps you up at night, because in Illinois, if you don't get at least 25% against the defendant, then it's not joint and several liability. You got to hit 25% to get that joint and several. Otherwise, you're stuck only with the percentage of the verdict. So yeah, I mean, what Dale Gallipo does is just remarkable, and I loved listening to his podcast. He had some just outstanding advice, and he's as good of a guy as he is a lawyer.
He is a great guy. But you are teaching quite a bit here at Huntington Beach this year, so I'm pretty stoked about that. You're going to give a 1-hour lecture on what?
Big damages.
Big damages. That's
I want
what we like to hear.
big damages. I mean, let's just get right to it. That's at the end of the day, when you sign up a client, what do you want to be able to promise them? Big damages. That's the goal. So I think that I have had the great benefit of learning from the folks I've mentioned so far, my dad and others, and then applying it myself, kind of adding my own twists. And so there are just certain concepts that I think really, really drive big damages. And they're not necessarily all unconventional, but it does have to do with pushing the envelope, going outside your comfort zone, figuring out the limits of what a judge will allow, and how far you can push it to really try to do the best you can for your client. And quite frankly, not only for the current client, but for your future clients. My philosophy is that if the defendants are going to push me to trial, I'm going to ask for more money than they could ever have expected me to ask for, 2-3 times what they maybe thought we would request. 2 years ago, or I guess now 3 years ago, I had a case where a guy broke his arm. He had a malunion, so they had to take the rod out, put it back in, and then it healed. He had some pain in his wrist. I asked for $15 million. We got 3.8. It was a $1 million policy. They didn't want to pay it. We got 3.8. We did all the things that we do in bad faith and in collections, and they paid 3.8. So that's just an example. But if I'm going to go to trial, I'm going to ask for a lot of money. And the folks on the other side, defense lawyers, insurance companies, they got to know that you can deliver. And so I want them to think I'm a little crazy. I want them to think that they have an enormous risk profile by being up against me, because that's going to drive better settlements for your clients, And then when you get that opportunity, because that's what I really consider it, when lawyers come to me frustrated about how a mediation went or how what the offer is, you can't be frustrated or mad about that. You got to be happy about that. You have to accept that as a challenge. You have to accept that as an opportunity, because the best verdicts that we've had, it's because the other side made mistakes. They undervalued it for one reason or another. They overvalued their liability defense, whatever the case may be. They made a mistake, but you got to be able to make them pay for that mistake. And I think that starts with going big and being bold. And so I think in terms of what people can expect from that 1 hour lecture are some of the specifics that we do, from discovery, voir dire, weaving it through every witness. And then in closing argument, it won't be a full hour on closing argument, but I probably will spend a good amount of time on closing argument, because while I do believe that a lot of the time, so in Illinois, we have 12 jurors and it's got to be unanimous. I think a lot of the time they've pretty much got their mind made up on liability by the time you get to closing argument. I think closing argument can move the needle a bit, maybe get people amped up. If you've got some defense jurors, you can kind of cool them down by pointing out some of the illogic to the defenses and why it doesn't make sense and all that. But I do believe that you can have a profound effect on closing argument, on damages with closing argument. And so some of the ways we do that, I think will be helpful.
I mean, in addition to that, you're teaching a 1-day MedMail masterclass on Wednesday, June 4th. And I know you've broken down these topics quite a bit. And because it all starts with case selection, am I right? The intake.
Yeah, I mean, if you do med-mal and you're fortunate enough to be in a state where med-mal victims can actually get full and fair compensation, there's a little preview on closing argument. One thing I say is any negligence, a cause, and I've got arrows pointing to each. Any negligence, a cause, full damages. The reason being is any negligence is too much negligence. A cause, because that's the law. Illinois has got a good proximate cause instruction where it need only be a cause, not the last or nearest cause. And then full damages. And what I love about talking about full damages is it's a concept that I think everybody can get behind, but the word full doesn't appear in the IPI, in the pattern instructions in Illinois. And so when I say full damages in closing, I sit down and I pray that the defense lawyer points out that the word full does not appear in the instructions. Fair and reasonable appears in the instructions, but not full. And if I'm lucky enough to where the defense will point out that the word full doesn't appear, and even though I was harping on that throughout my initial close, I can get up in rebuttal and I can really make hay with that, because what are they trying to say? That it should be half damages, 80% damages? 97%, 99% damages? That doesn't make any sense. They're responsible for all the damages.
Salvi, you got distracted. I said case intake.
I did get distracted. You said case intake, and I went straight to closing argument. But you got to be thinking about closing. Even
yeah, exactly. What do you got? You got attention deficit disorder?
I do. Don't we all a little bit if we're going to be
you got it.
busy as we
to a
are?
higher extent, though. I'm just pointing it out.
In medical malpractice, case intake is so critical. A really good lawyer around these parts once said, "You're never going to go broke rejecting cases." And that's true. The last thing you want to be is 3 years and $250,000 into a medical malpractice case where there's no offer and you can't figure out how you're going to win a trial. So case intake is huge. I'm going to be talking a little bit about specific types of cases and what we look for in terms of specific cases, whether it be surgery cases, cancer, delay in the diagnosis of cancer, emergency room cases, birth injury cases, cases that involve vascular issues, hospital stays. We'll talk about some specifics there, as well as, and that kind of bleeds into another topic, and that's hiring experts and making sure you're getting good expert reviews. You don't want false positives. That's another dangerous territory where you have an expert that didn't look at the whole file and says, yeah, you got a case here, and then you're off and running. So case intake, it's so huge, and I will never ever take a case saying, well, we ought to be able to settle this. If I take a case, it's because I hope they don't make an offer. I would love to go to trial with no offer, take the pressure off of us, and let's go to trial on a no offer malpractice case, because if I've done my job at case intake, it's going to be okay.
The highlight of TLU for me was having the opportunity to network work with attorneys from out of state.
TLU has been amazing. I'm so glad I came. It was one of the most inspiring events I've been to. Great networking, great food. It's been amazing. I can't wait for next year.
As far as drafting the complaint, what do you do when you draft complaints that you think different than what other folks do?
To me, complaint drafting is everything needs to be with an eye towards trial. Absolutely everything. One of the problems with a malpractice case is a lot of times you get a set of records, the statute of limitations coming up, and you get a set of records, and the client called you 3 months before the statute, and you're looking at the records, and you know that after you institute a lawsuit, if it is a case, that you're going to get a different set of records, or you're going to get more. Something's going to change. The facts as you know them will not be exactly the same now as they are later. And so you try to do all the diligence that you can. But when you draft a complaint, you got to keep your options open. So one thing you have to do is, what are my empty chairs? You can always dismiss people later, right? So unfortunately in malpractice, a lot of times you got to sue everybody. But you have to focus and think very carefully about what are your empty chairs, because like rats on a sinking ship, medical malpractice defendants, as long as they're all together, they will not blame each other. They know that is a bad idea in a malpractice case. They're not going to blame each other. It's not like other types of cases. Very rarely will malpractice defendants blame each other. So, but once there's an empty chair, you can bet your ass they're going to start blaming the empty chair. I've seen it. I've seen a defendant settle out, and then the other defense lawyer became a plaintiff's lawyer. It was unbelievable. His approach to depositions totally changed because one of the defendants had been settled out. So I try to avoid empty chairs. That's number one. Number two, in terms of at least whatever your relation back law might be in your jurisdiction, you got to leave some avenues open for what you might learn in the future. So in addition to naming folks, I try to be very widespread in the allegations I make so that the same transaction or occurrence can apply to invariably everything that occurred to this plaintiff. And that includes, for example, institutional negligence. I think institutional negligence is going to be something that only becomes more and more important as we go forward. These health systems, they have shortages of nurses, they have shortages of doctors, and they're being run by private equity people who don't care about patients. And so institutional negligence is going to be something you need to know, because you're going to run into it. There's going to be negligence that arose because they don't have proper staffing or proper incentive structures, or they don't have appropriate policies and procedures. So, and then I also use them as requests to admit. I try to keep my allegations simple, straightforward facts, and we litigate the complaint and the answer to make sure we get good answers, because that's going to allow you to, number one, get after the proper defendants as soon as possible. And number two, you can get some good admissions there that you can use later. I use, answers to the complaint malpractice cases and depositions, and a lot of times they answer it one way and then they realize that that's bad for the case, and then they're going the other way. That's a huge credibility hit for the defense. So you can do a lot with the complaint. Number one, preventing defenses, and number two, kind of weaponizing the good facts that you have.
And I'm looking at the rest of your topics for this. You have maximizing your evidence through discovery.
Yes.
Trial prep.
Yeah, no, I mean, technology. You want, and this can be very challenging with judges and laws within your jurisdiction, but you want to press as hard as you can to get every last shred of evidence technologically. The audit trail, all the changes, all the notes between providers that might be buried in some other section that they don't produce with the initial production. There's a treasure trove of information that a lot of time that the defense never gives you by agreement. You always got to battle. You got to battle it out. We had a case that settled last June. It was about to go to trial. A good case, but a tough case, because it was a pediatric neurosurgery case, and there are only a couple hundred of those types of doctors in the whole country. And so they all know each other. And so we were probably in court 8 to 10 times trying to get an inspection at the hospital, trying to get additional audit trail information. But once you get it, it can make or break the case. I mean, all you need is that one nugget that shows that the defendant is not to be trusted. There's some credibility problem. There's some change in the record, whatever it might be, that makes them look terrible. And that can be the difference between winning and losing. So you got to go fight those fights. So that would be number one is some audit trail stuff that we're going to be talking about at the masterclass. And then just other tips on whether it be policies and procedures and the use of those, how we approach depositions, literature. You got to weaponize literature. That can be, I used to be afraid of literature. I used to fear that if I introduce this sentence from this piece of literature, then this other sentence in the literature is going to come in and that's bad for my case. But I have gotten much more risk tolerant with literature as long as you do it right. And so talking about peeling off the layers of the onion to make sure you can go deeper than the other side relative to literature. Because again, if you took a good case, if it's a good case, and what the experts have told you about your cases is true, then you should be able to find a lot of good literature that helps you, and you have to tap into that.
Got it. A lot going on in this med mal stuff, because I'm just going to hit you. I'm just going to cover the rest of the chapter headings here, because we have a couple more things we got to talk about, and everybody wants to see in detail what you're going to be teaching. It's right on the website. So you're going to be talking about trial preparation, voir dire. We're going to a little bit more on voir dire, because let me ask you, how many 8-figure verdicts you got in med mal?
In med mal, I think 4.
That's pretty good for 42. We're kind of keep clicking along. But the key thing is the jury selection. We're going to talk about that more in a minute. And then you have the adverse examination of the defendant, direct of the plaintiff's experts, cross of defense experts, closing and rebuttal. So that's going to be the med mal masterclass in detail. But talking about voir dire, because you're going to do a live demonstration of voir dire with a focus jury, a live focus jury in Huntington Beach. And so what's your philosophy on voir dire?
Well, yeah. So my philosophy on voir dire, first of all, you don't get a second chance at a first impression. So you got to, you want to make an outstanding first impression. So I try to do that. I try to make everybody very comfortable. I smile a lot. I try to be as likable as I can. I try to be my best self. I'm never going to argue or fight with the jury, with a prospective juror. In fact, my philosophy is anything bad that they might have to say about me, my client, my case, or the civil justice system or plaintiffs generally, you want to hear it.
Bring it out.
You don't want to suppress those things, right? You want to hear it. And not only do you want to hear it, you want to hear it early and often from anybody who might feel it. The term poison the well, it can happen. Sure, if somebody says, yes, defendant Dr. Smith is my doctor, she's been my doctor for 30 years, she saved my life, that's poisoning the well. But short of something super specific, people saying about, what their limit on damages might be, or how doctors are sued too much, or medical malpractice is a cash grab, or whatever it might be, you want to hear that. That does not poison the well. And in fact, you don't just want to hear it, you want to hear it so that you can then pivot to other jurors and see who might agree, because people are much more likely to give you their true feelings if they know that there's some support in the room, that they're not a lone wolf. Some of the potential leaders in the jury might speak up, but then you have other folks that want to hear from someone else first before they're willing to admit their true feelings. So I just try to get a good discussion going. But I have an order, I have a procedure that I kind of walk through. I don't want to just come out of the box and say, if the facts and the evidence, or if the facts and law support a verdict in excess of $100 million, could you sign that verdict? If I came out of the box with that, and that was my first impression, I don't think that would be good. I think that would validate the feelings that I'm the greedy plaintiff's lawyer. So you got to build up to that. You have to get their trust a little bit. You have to show them that you're able to empathize with them. And so, for example, some of the things I've done just to start out, one of the things I used to do before they got rid of this video is I would reference this really old Cook County, in Chicago, that it sits in Cook County, and Cook County would have this old video where Lester Holt looked like he was a teenager, and one of the sitting judges looked like she just got out of law school, and she's been a judge now for more than 30 years. And so it's this really very obviously old video. They've since gotten rid of it, but it was fun to talk about back when they were still using it. And I would make a little joke about the video, about how Lester Holt looks young, and people would kind of laugh. But then I would hearken back to some of the important aspects of that video. So I like to come out and keep it kind of light and bright to start, but then I want to get back to emphasizing the importance of their service. So, for example, the chief judge at the time in that video would say, it is the mark of a great country that puts such trust and responsibility in the hands of its citizens. So I would repeat that line back to the jury, and I would say that, that's very true, because you all are going to be, if you're impaneled on this jury, the most powerful people in the county. You're going to decide this case. So then I'll build up to it. Now, you got to have your juror specific stuff that you're going to ask. I think medical people, I think you should be very careful about allowing medical people onto your malpractice jury. Even doctors and nurses might be the most obvious, but even, physical therapists and other healthcare providers, you got to be very careful. So I'm going to talk a lot about what I do to try to get cause challenges for those people. I've been pretty effective in doing it. So that's something we're going to talk about in the masterclass. But then getting to the money question, you need to have a case, obviously, that justifies asking for such a large amount of money. Let's take the case, the $76 million verdict that we're going to be talking about in May on the webinar, and some of the lessons from that case that I'll incorporate in the masterclass as well, where you had a brachial plexus injury where my client had barely any use of her arm. And then you had a brain injury that, while it didn't incapacitate her insofar as she's not wheelchair bound and tracheostomy and G-tube and all that, but it's a real brain injury that has had significant cognitive effects on her, even though that was somewhat in dispute and part of the trial as well. And so you ask the jurors, has anybody ever heard of the brachial plexus injury, where the nerves that connect to the spinal cord that then innervate each of the arms are literally pulled out of the spinal cord? Has anybody heard of that, like a brachial plexus avulsion? And typically the answer is no, because it's a little too granular and unique of an injury, but at least they know, okay, this is bad. How about a brain injury where there's been a trauma during the birth process that led to brain bleeding and ultimately a hypoxic ischemic encephalopathy? Has anybody heard of that? And again, typically the answer is no, or maybe some vague answers like, oh yeah, I have a nephew who has, autism, and then you kind of distinguish, that situation from this situation. But by and large, nobody's had that experience. But then they recognize, like, okay, somebody has been profoundly injured. Now you ask about the money question. It's more palatable when you've done it in that order. And so you have to think through those issues as you're figuring out, how you're going to walk through voir dire. And that's what we're going to talk about in the masterclass, is how I do that in malpractice cases.
Well, actually, let me just, the masterclass you're talking about a little bit, but you're actually going to demonstrate it with the focus jury.
True.
Just so you know,
That's
and
right.
all these live focus juries that we're doing with Raleigh, with you, with Ben Rabinowitz, Ben, I forgot to mention him, Inner Circle guy, great guy. He's doing a masterclass on cross-examination, and then he's doing a wrongful death voir dire with a live panel. But all these masterclass that you're doing and these live voir dires are all going to be recorded and on TLU on demand, just because people want to be antisocial, not come to my live events. Do you think that's going to cut down on my commitment to help them get better? Only a little. I mean, I'm hurt that they don't want to come hang out in person, but everybody's got their thing. Not everybody's that social. What can I say? Or, you know what I mean? They just don't like theme parties every night out on the ocean lawn or full breakfast and full lunch. I mean, that's their prerogative, besides all the great learning. But
yeah, well, you're still devoted to their improvement.
I'm still committed to their improvement. It was nice. This guy, occasionally I get, text message or email about somebody's success. Like, what was great, this guy, Michael Driggs, I met him at a Trial by Human workshop that I was hanging out with Nick Raleigh. And then he came to TLU Vegas, and then he's a young guy, only 2 years into his legal career, out in Utah, which is not the most generous places, but in federal court, he was telling me about, and I'm going to do a case analysis with him, but he got a $4.5 million verdict in federal court. I got a $200,000 offer, so I was really stoked for him, and it's just like so exciting because, it takes so long to figure this shit out, but you were fortunate to have mentors, like your dad and I think Shostak and these other great lawyers at your firm to teach you and coach you, but most people don't have that. Most people are on their own. Most people are just, wandering around and, without that help, without that guidance. And it's really hard. It's really hard. And it's, demoralizing when you get your face punched in. And so I was just so happy for him having that happen. Just want to note also, I think November 12th through 15th, we are going to, in Vegas, we're going to do a med mal boot camp which I'm super
Yes.
stoked about my boot camps because I'm doing one with Satch Oliver and John Romano on depositions or trial and damages, April 1st through 5th. I got one coming up with, just one that I teach without the other folks, like May 7th through 10th, where it's just training skills. And I'm going to, at the end of this program, I always do my defense medical expert voir dire, because people got to always, not voir dire, cross-examination, my bad. See that? Hypoxic brain injury. I think my brain's not getting enough air. But November 12th through 15th, because so that boot camp, I'm doing with Joe Freed too, I think in August on trucking cases. And I got a whole bunch of them lined up, like Kimball Jones on insurance bad faith, but we're going to do yours the 12th through the 15th in Vegas on med mal. And so it's going to be a combination of learning the skills of presentation and connection, the eye contact, the hand movement, the voice control, the glance control, but also having Pat help you with your various med mal cases, because it's really like, and helping and meeting up ahead of time, knowing what people's cases are and helping with each aspect of the case they're having challenges with. So that way they learn the skills of presentation and in context with their own cases. So they get out there and, get better on their own cases, which is so important. So I'm super stoked for that because, the best part about all this, Pat, I get to be there and learning from everybody too. So I'm learning so much.
I can't wait. I mean, you go in ebbs and flows, because I'm not immune to getting complacent and feeling like, okay, I've got this figured out. And it's when you start feeling that way, that things start to break against you. You cannot get complacent. So I'm looking forward to it as well, as in addition to Huntington Beach, so I can learn from all these other great trial lawyers, because you got to stay ahead of the curve. That's the only way to do it.
Right. And these people are coming too. I'm always excited about it too, because like these people are really committed to their craft, working on the same type of case. Because we did it with like David D. Robertus on employment cases a few months ago. But you get the smart people that are committed and, showing up and really working, and it just gets so much better. And then after the fact, I create a listserv with the group, so that way the group can stay in touch and continue to, help each other on the cases. So I'm looking forward to that. So Pat, we're at the end of our podcast, but at the end of our podcast, you know what we do now? Every time we do a little bit of cross-examination, because I used to be a criminal defense guy for many, many years, and I always thought that was my strongest part. Like I've studied, I've done a lot of cross as a criminal defense lawyer. That's all you do is cross. You don't really, although I did put my witnesses up a lot, just because if they liked my client, they believed my client, it's gonna be real hard to put them in jail and convict them. Cross-examination, Salvi. I know you're probably, because I asked Panish. I said, Panish, this is when I first met him back at the beginning of the pandemic. I'm like, Panish, what part of trial you think you're best at? And of course his answer was, all of them. I said, well, if you had to pick one, what would it be? He's like, cross. I know how to find the friction. And I'm like,
that's a good Panish.
Thank
you.
You
Do a good.
I've been working on it. It's St. Patrick's Day. I'm finally in LA for the first time on St. Patrick's Day. And he decides he ain't having a St. Patrick's Day party, because all I hear about, because you're Irish too, right? I assume.
Well, mostly more
Oh,
Italian.
yeah.
Salvi.
Right, Salvi. But do you have any Irish in you? You have to have some Irish in you. You're in Chicago.
I got a little,
There's got to be. Look how light skinned you are, man. That sun's, you're dangerous out there.
Northern Italian. Yeah.
Okay. But anyways, I only bring this up because I showed him this cross, and he actually uses it in every deposition now. And he only had one trial since then, and he settled it after he put up a couple he didn't get to the expert witnesses. But here's you ready for the cross, Salvi?
Yeah.
So here's the skills I think.
Am I playing a role?
Yeah, you're gonna be the doctor. Just say yes.
I'm the doctor.
Yeah,
Don't fight you too much.
Well, for practice purposes, good, just say yes. But I realize in the real world, they're not just gonna say yes. But to practice, you have to have repetition. And like, frankly, with these questions, their answers are just blah, blah, blah. It doesn't matter if they don't answer, specifically. I would just re-ask the question. True. But we're not gonna have that problem with you, are we, Dr. Salvi? You're not gonna be difficult. Not too bad. But anyway, so here's the key skills that I think must be mastered and trained in cross. The obvious ones they're obvious, but people still violate these rules. And this is like leading questions only, and one new fact per question. Asking compound questions is a disaster, because it just gives the witness an opportunity to run on. And even like if you say, is that true? No, that's not a leading question. A leading question does not begin with a verb, right? So anyways, any questions that begin with a verb, bad in general, unless you're intending to ask an open-ended question because you're not worried about the answer and you want them to actually lie, so you can, impeach them with a lie and still get your answer out. So there's exceptions to all rules.
Yeah.
But so leading questions only, one new fact per question, looping, which is to establish a fact and repeat that fact in the next statement. You know, like, doctor, you're board certified. To become board certified,
Correct.
this requires advanced education. This education, it takes place in medical schools. Because you see, each sentence begins where the last one ends. Very easy to follow, like breadcrumbs, right? But people don't do that because they don't prepare. They write a topic on the top of the page and think that the great questions are just going to come to them. And maybe after you've done it for 20 years and you've written out your questions for 10 years, maybe they do. But for most people, it just doesn't happen. It just doesn't pop into their brain when they're under pressure. Not that I've seen, not in the transcripts I've read. Cross-examining in the present tense. Most lawyers cannot do this. Everything is in the past. You walked into the room, you drove the car down, you ran the red light. Whatever it is all the past. But if we can train ourselves to cross in the present, it forces us to visualize the story, forces the witness to visualize it, and most importantly, allows the jury to picture or visualize the story. Dropping all the taglines like right, correct, isn't it true? Dropping all the filler words like and, so, okay. Because people will have that crap bogging down their cross unless they train themselves not to. Oh, as far as the taglines, like, doctor, you're board certified. If, in fact, you're not comfortable with it, or the judge is like, is that a question and really harassing you, then it's better if you let some pause before you say the truth. Instead of, doctor, you're board certified. True? Saying, doctor, you're board certified. True? And now it allows that space for the mind to process.
You got to hear the question.
Right. Well, to process the information and then say true. But pacing, most people speed up on cross and they don't breathe. So to slow yourself down, every time you pause to inhale, and that way you're allowing yourself to slow down and you're keeping your lungs full of oxygen. So that way, so many people, like, they tail off as they run out of air and their voice drops because they don't have the power to propel it. But because they don't breathe, because they're nervous. And so we have to train ourselves to pace, to slow down, and to breathe. To effectively use a flip chart to anchor our points. That means putting one topic, writing legibly and putting just one topic per page. Being intentional and control of our emotional state. So either we're inquisitive, like for the foundational cross, or we're disappointed when we impeach. But we're always in control. We never get frustrated. We never get angry. I mean, some people are like, there's moments to get angry. Well, you know what? If they say there is, there is. If it works for them. But, I like Joe Fried when he says, when you get angry or frustrated and cross, it's like you gave the witness a little remote control and they just get to push the buttons and anger, frustration, right? Because they're getting control. If you lose your control at all, you're giving them control. So
I agree.
And this cross that we developed, I actually developed this cross with Craig Peters because it used to be the cross of an investigating police officer. And I used to tell people, cops, doctors, the same thing, similar cross, because the society puts them on pedestals, and we don't really believe that they would lie. And to get the jury to believe that they're actually lying, you really have to be clear with your impeachments, or else they'll just think they made a mistake. And most people skip over laying foundations, putting the foundations down before they get to the impeachment. And when we do this, it really takes away a lot of the impact of the impeachment, I believe. Now we're going to run the cross. You ready, Dr. Salvi?
Let's go.
All right. So let me just go from the beginning. You're board certified.
I am.
To become board certified, this requires advanced education.
Yes.
This education, it takes place after medical school.
And during medical school, but both.
All right, yeah. And like I was going to say, but while you were in medical school, you did take classes.
Of course.
One of the classes that you took was on how to conduct a proper medical evaluation.
Sure. More than one class, sure.
You're trained that a proper medical evaluation, it must be impartial.
Not sure what you mean by impartial. I think we take down the facts as they're presented to us.
So at this point, I would ignore your dumb answer, and I have my flip chart right here with a blank sheet, and I flip it over, and at the top it says proper, and then there's a line underneath that I put number 1, impartial. And then I put a number 2. And I trained myself to write legibly, and so that it takes up the entire space of the page, because I want to space out my writing so it takes up the whole page. So, well, doctor, by impartial, what we mean is that you're not an advocate for either side.
No, I'm just taking down the information as the patient gives it to me, as well as whatever my physical exam findings are.
Doctor, you're trained that a proper medical evaluation must not only be impartial, I look at it, use my hand to gesture towards it, but it must also be objective.
Yes.
So I write down objective, and then I put number 3. By objectives, what we mean is, so there's parallel structure, right? What we mean is that you don't cherry pick the evidence to support a desired opinion.
That's correct.
Doctor, you're trained that a proper medical evaluation must not only be impartial and objective, but it must also be complete.
I would agree with that.
So I write down complete. Now it covers my whole page. I say, doctor, by complete, what we mean is you consider all relevant information.
You have to. I agree.
Doctor, the opposite of a proper, so that's the right way. Now we're talking about the wrong way, right? And this cross can be used on any type of expert. You just got that first part would stay the same. You just have to adjust the second part a little bit. Doctor, the opposite of a proper medical evaluation, one that's impartial, objective, and complete. Well, that would be a biased evaluation.
You wouldn't want to do that. I would agree.
Doctor, you're trained and you know that there are certain risks associated with a paid expert's choice to conduct a biased medical evaluation.
True.
One of these risks is that the jury could be misinformed. So that's where we bring the jury in, right? And so, like, some people are comfortable talking to the jury the whole time when they ask questions. I'm not. I don't think it's, and I personally don't think it's as effective. I think when you turn and you say something to them, it should stand out. So it's that the jury could be misinformed about the patient's condition.
You're right. That needs to be avoided.
So I flipped the page over. It says biased. I put number 1, misinformed, and I put number 2. Doctor, you're trained and you know. So that's stepping, right? You're trained and you know. It's like a universal truth that if a paid expert chooses, of course, I just called you a paid expert for the 4th time, to conduct a biased medical evaluation, not only could the jury be misinformed about the patient's condition, but they could also be misled as to the extent of the patient's injuries.
Yeah, that's true. That could happen.
So I write misled under misinformed. I put number 3 because more is coming. Doctor, you trained and you know that if a paid expert chooses to conduct a biased medical evaluation, not only could our jury be misinformed about the patient's condition and misled as to the extent of the patient's injuries, but perhaps worst of all, they could be deceived into undervaluing the human harms and suffering that were caused.
Or overvaluing.
You notice my tragic tone. So I changed. So I'm emotional state. I'm always in control. So then I write deceive. So it says misinformed, misled, and deceived. People are much more likely to believe that the doctor will deceive them if he's willing to misinform and mislead them. So that's called stepping 2, getting the people's minds open to these concepts. So then the conclusion. So doctor, here's my question. So I call that refocusing move, like squirrel. Like the goal fact. Like every time we do cross and we run through those 20, 30 questions, we get to the goal fact. Or let me ask you this. So now it's called a refocusing move. On December 20th, 2022, you had a choice to make. So tell us all, what did you choose to do?
I chose.
Now, most paid experts worth a shit are going to be like, what do you mean? Because it's totally an ambiguous question, okay? They're not going to guess. So what do you mean?
I chose to do an impartial, unbiased, complete examination of the plaintiff so that the jury would not be misled.
So just so I'm clear, you're telling this jury under oath that you, in fact, chose to do a proper medical evaluation.
That's
I
right.
flipped the chart over, makes a bunch of noise. One that was impartial, objective, and complete, like you were trained to do. And you didn't choose to violate your training and conduct a biased evaluation. So I flip it back over because you knew all the risk. Is that what you're telling us here today, doctor?
Yes, I am.
Okay, great. So come down and put your name, put your initials on the board. But the beauty of this is it draws a line in the sand, right? Because you're calling the doctor a dishonest liar and biased without saying it. And how many experts in your entire 18-year career for the defense have you ever come across that based upon these definitions you say were impartial, objective, and complete? 0, right?
I think if you have the goods on that expert in terms of, what's going on with their examination, then that is a great way to start.
Yeah, if you don't have the goods of the expert, you'd be an idiot to run this cross. When somebody's like, well, I don't have any impeachments, what should I do? I'm like, don't do this cross. You're going to look like an idiot.
Yeah, I mean, just confronting the defense experts directly on the patient's history. The patient gave you this history, walk through each sentence in the examination, and I'll say, and you believe him. Do you believe him? You know, so and so says he's having pain in his foot on a daily basis. You believe him? And then they got to make a choice right then and there what they're going to say they do and don't believe. It's a tough one. It's a tough position for them to be in, and it's very effective.
Yes, and that is when we get into the substance. But right before we get to the substance, we have to lay our foundations, Mr. Salvi.
Of course.
So you know what? I just did a podcast with Ben Rabinowitz last week, and on cross. It was just on cross, but I thought it was I really learned a lot. I cannot wait to see how the public and the community like it, because I think it's really great. Oh, and like this cross could be adjusted for any expert, because it was like a biomech. Then the first three are the same, but what are the risks? Is that the jury can be misinformed about the forces involved in the crash, right? And they can be misled as to potential for injury, and finally deceived into the human harms and suffering that were caused, the damages that were caused. So it's adjustable. And I think people need some, good structures to start with, Mr. Salvi. That's what I think.
Terrific structure. I
right.
remember the structure from Dale Gallipo's podcast having to do with a police officer. So it's a chameleon structure. It can apply to a lot of different types of cases.
Right. But it's the most important thing is people prepare, not count on, their intuition that's going to hit some brilliance that's going to hit them in the moment of trial.
I agree with you wholeheartedly. I intend on talking in Huntington Beach about how I prepare, and it is a meticulous process. I mean, there's no substitute for just hours. So when you say standing up with an outline and then kind of winging it with your questions, that is not how I do it, not even close. And so when I talk about giving the defendant no oxygen, I mean no oxygen, where if I get anything other than a yes, the jury's going to be looking at a medical record or a deposition or a piece of medical literature or something where it just shows that this guy or this girl is not being forthright with them. And if you construct your adverse or cross-examination where that's all it is, and you cut out all the fat, the impression that the jury is left with that witness is they can't be believed. Any good that was done on direct is now gone, or any good that might come afterwards is meaningless because you have destroyed the critical witness of the defense. And I look forward to really getting into that in the masterclass and at Huntington Beach.
Good. Pat Salvi, how do people get a hold of you? If they got questions on MedMail or anything in Chicago?
Yeah. P as in Patrick, Salvi, S-A-L-V as in Victor, I, the number 2 at salvilaw.com. Salvi2 at salvilaw.com.
Is your dad P Salvi 1?
There's no one. He's just P.
He's just P Salvi. All right. And if anybody needs to get a hold of me, of course, it's Dan at triallawyersuniversity.com, or my cell is 248-808-3130. Nobody ever calls me, though, from the podcast or texts me. Occasionally, I get a text or a call. I always makes my day when people do call me or text me and like, oh, I really learned something here. I got something special, or you know what? Even they're like, you know what? You got to shut the fuck up on your podcast and let your guest speak more.
I doubt you get any texts like that.
Occasionally I do. I ran into this guy at Pash's conference. His name was Noah. And like at the beginning of the pandemic, when I started doing the webinars, he says to me, he says, man, I really enjoy your webinars, but you talk too much fucking much. Can you shut the fuck up for a while? And I'm like, you know what? I'm going to work on it. Okay. I appreciate you giving me your brutal honesty. Hey. That's what I appreciated, was his brutal honesty in that fact. Oh, and another thing, if you're thinking about coming to Huntington Beach, don't wait too much longer, because the hotel rooms are going fast, because we buy out the whole hotel, but there's only 250 rooms in the whole hotel, and there's probably about I got to take a look at the inventory, but about 60 left right now. And it's a great hotel, and the hotels nearby, there's some that are less expensive, but they're not nearly as nice, and some that are more expensive, but they're not as nice. And in fact, but they're not the hotel where everything's at. So why would you not want to stay at the hotel where everything's at, Salvi? It's not as much fun. You have to like travel back and forth. You got to be there. And if you're not there, you got to ask yourself, what is wrong with somebody who has a hypoxic brain injury if they're a lawyer and they're not at TLU Huntington Beach? That's all I can say.
Well,
I'm just going to leave it at that.
I can't wait. We're going to be bringing a huge contingent of our firm. And
I can't wait to meet the rest of the people at your firm.
I can't wait to talk about some of this stuff, but also listen. I mean, whether it's Trial Lawyers University Illinois trial lawyers, I think everybody should have the thought that, you want to give and you want to take. You want to learn from others and take, but then give back in any way that you can. And that's what makes the plaintiff's trial lawyer bar so unique. We share with each other despite the fact that frequently we're competing with one another.
Right. And your boy Kurt Zahner is going to be. That's how we know each other, is from our buddy Kurt Zahner. Right. I love that guy.
I can't wait to hang out with him.
He's been such a great contribution, like, to this organization, because he started coming around. I met him. I'm like, hey, I'm Dan Ambrose. He's like, yeah, no, I met you 7 times before. I'm like, well, you just need to be more impressionable, more memorable, buddy. Yeah. Don't get bad at me because I can't remember you.
Yeah.
Do something to make yourself stand out, like now, being an asshole to me. Now you're going to stand out. Now I'm going to remember you. All right, Pat. Happy St. Patrick's Day, even though you're only a little bit Irish.
That's right.
I'm going to go call Panish and bust his chops for not having a St. Patrick's Day party the one time I make it to town.
Yeah, you should.
I'm looking forward to moving back here next year. Oh, everybody, there's no Vegas this year. Only Huntington Beach. You got one chance to learn from the great ones, because Dan Ambrose, yours truly, is going to have to go from the podcast host, the webinar host, the conference host, to the trial lawyer this year. So after June 7th, I'm going to trial. People are like, you got anything lined up? I'm like, nope, but I will after June 7th.
Very good.
I'm going to be open for business. Take care, Pat Salvi.
Thank you, Dan.
Peace
Thanks
out.
for having me, man.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.